kiti bunkono akwa man sonala so the reason so me be for kan law la court is quoting the law amango ko me aka ani diala for abe law la court kan anu ako gambia la law bu mi alon ko mada bakele. So then the process have to be straight, have to be according to the standard. So LSB will focus. We're really sad that okeda kude me alon ko wala hapunta ni kiti bunko na bi when you are back anung ay kijo for a bag en kijo for a bag mobile amoy afon la so LSK ko yem photo ko wala fa ya record put it in the record. I'm coming, put it in the record. So diamo, but now it's recorded by us, it's recorded by the journalists, and I know this is going to be headline. We believe all of you people have to put this headline that the judge told the defense lawyer that even if you talk, I'm going to overrule you without hearing from him. So the ball left to your court. Bari ni evidence ebe fungo sama na sede jaro sama na jannen kito ko sede jaro nyun tafolo e ka sede jaro nyun jibele fo asa tano kiti bun kono bam fata tano kiti bun kono eles kat na la ko nyanda kawla ko indi folo bar to nyabe sabar la dam yon ko ala lo membe kete ala baraka
no what is demanding the English, please what you say is very important.
No, I beg, we have a meeting at the police headquarters. No, we have a meeting at the police headquarters.
Brief in just in English.
Short brief.
Anyway, all what I'm saying is we've all seen what happened inside the courtroom. What surprises us was this: a judge telling a defense lawyer that even if you talk, I'm going to overrule you without hearing from him. We are really shocked with this information. Without hearing from him, you said to him, whatever he said, you are going to overrule him. That is a shocking information from a lawyer, from the state judge. What is more important is this. We all seen there, 𝒂𝒄𝒄𝒏𝒆𝒍, the case involving Dr. Banja. The audio was tendered before the court, but it was not accepted because of the nature it was. So LS want to tell them the nature how the process is being done. It's not correct. It's not to the standard. But the guy rejected him. But we know, inshallah, next court tomorrow. Let us come here tomorrow. This case is very important, and we are calling on Gambians. Whoever want justice to be served to everyone, please come and attend this court session tomorrow. Bob is a young man who have 2 killings. This is really saddening. Thank you. Allah Barak.
Okay, bari mo coming ka fanya lamit member diam la sunshine thing coming I mem for joje mem for bobla loy konto ayole fo so akam to ko wala be kelin sai right now akola new me anyo tora afenti nyay modul je me aron ko la faga nyini ka dama ninge na mi rafa la ba ni kala de excuse
she's very influential and she's very lucky
Oh my God, my thing is off.
I'm back.
Guys, are you ready? Yeah. Ms. Gomez, you were in the court throughout since from morning up to this afternoon, and tell us what's your reaction. What have you observed in the court?
I'm still optimistic, and having in mind that
the results are going to be negative in regards to Baboucarr Keita. A little bit disappointed the way the proceedings are going, because to me it just looks like a show happening. Apparently nothing is being done according to law. The procedures are being flaunted left, right, center. And for me, it's a cause for concern. But set and done, we're just waiting for the results. I'm sure when the results are read, we will all be able to go home knowing that Baboucarr Keita is not the father of this late baby.
Why are you so optimistic about it?
Because I know my brother, and he said he didn't do it. And I believe in him.
So li nga xam ne moo jot a xew fii bu yàggut rek am na kenn si seen collègue si ku wax ne daal ni nga xam ne moom la kii boobu muy defal sant ni moo wax ne daal nekkul si yoon maanaam mi ne leen ne daal loolu daal xaw ma.
nekkan nu mooy waxee.
ki nga xam ne moo nekk George bi nga xam ne moom mooy loolu.
loolu laa fi jos wax ni bu yàggut nii rek soo toogee foofu noonu di seetaan da nga mel ni kuy seetaan show. Melut ni court nga in a court nga nekk a high court of a country, because normally if you're familiar with high courts, everything liñ def it's da nga am procedures and rules to guide you, and lolu nekko di xew. So basically nita talk rek di def nim ko nexe, even the state councils are trying to guide and direct him to say, okay, this is the law, this is the procedure, why mom mu ne lu ko neex la moo def. Why at the end of the day lolu li ko neex la. Why li gëna important mooy results boobu noonu boo xam ne moom amu ci contrôle bindu ko te moomu ko. So li nekk foofu la ñuy xaar suma gom-gom may ne li fa nekk mooy ne Baboucarr Keita jurut xale bi, and loolu mooy suñ ñaan te mooy suñ gom-gom te man yaakaar naa ne loolu mooy am.
so jamono ji rek soo doon war a wax ak ñi nga xam ne ñoo nekk si diaspora bi parce que bari ñu ngi jaaxle si case bi because tey leen wax waaye tamit yoo occasion bi ëllëg looy wax gaay.
Well loolu dëgg la, I mean last bi ñoo ajoon xam nga boo leen bàyyi xel defense bi prosecution bi ñu ngi doon dem back and forth about the rules and lan moo war a xew xam nga. waaye even though li ñu wax ne loolu moo war a xew nga am George bi ne déedéet man nii laa ko defee, waaye tey ñu ñëwaat bi fii nii ba results bi ñëwee ba expert bi ñëw mu changeaat na mu waxoon ne loolu la moo def tey defut loolu leneen la wax ne la moo def moom ni mu ko neexee. waaye again rek changeut results ba liñ bind si kayit googu noonu. So loolu la ñëpp di xaar hopefully dinañ ko xam tey o dinañ ko xam ëllëg, parce que li mu wax mooy ne nañ copy results yi and then ñu jox ko defense bi ak prosecution bi. So both sides of the parties will know maybe in the next 30 minutes or so. ñu ngi wër court house bi yëpp na amuñ fuñ ko copy. So hopefully finally dinañ ko copy, den ku nekk nga xam lan moo fa nekk, den su boobaa xëy na yéen it di ngeen am opportunité pour xam li fa nekk. te ñëpp a ñuy seetaan ñëpp a ñuy xaar, parce que réew mi yëpp foo toogee si court bi yaa ngi fiir ni ñëpp a ngi xaar, ñi fi nekkaa ñi fi nekkul ñëpp a ngi bugg a xam benn ting boobu noonu. So hopefully dinañ xam suñ xamee nag den muy loolu rek den ñu seet suñ jubluwaay naka la.
am nga yaakaar ak gëm nga li nga xam ne moo nekk ñi seen test bi nga xam ne moom lañ def Gambia.
sa question bi leeral ko.
ma ne la am nga yaakaar parce que ñu bari ñu ngi wax ne li nga xam ne moo nekk DNA test bi ñoom boobu ala nanguwuñ ko parce que amul lu leen ci ut na yow am nga yaakaar ne lii daal ñu ko déggoo.
seen jëfin moo satutoon loolu moo tax xel yi ñu bari mu teey. so waaye loolu terewut li nekk ci kayit googu noonu, waaye jubluwaay bi ak jëfin bi ak process bi dafa satutoon, dafa bari woon ay laxa-laxa yu bari. loolu moo taxoon ku nekk di wax ne suma xel daf si teey, waaye léegi loolu yëpp romb nañ ko. loolu am soo defense bi dinañ indi loolu yëpp su dee appeal jar na appeal, waaye tey li ñuy wax mooy results bi la na fa nekk. ndax boobu la nda du boob, ndax Baboucarr la nda du Baboucarr, ndax du ñoom ñaar yëpp keneen la. xëy na result bi dinañu woon loolu, den su loolu feeñee ba pare den ñoom it dinañ xam seen jubluwaay naka la. jërë ngeen jëf.
So Kek Sane live right now.
By the defense counsel, it was a very heated one. That's all. Francis was just a person who was actually not been privy to any DNA sample collection, the extraction of the blood, the custodians of the blood. So he's just a mere person who was just given the blood sample just to transport it into Ghana. So for them, they feel like he's not an expert in this area. He was just given a blood sample that he didn't actually confirm whether it's the blood sample of the accused person and the 3 persons that are involved, because he was asked whether he actually know. He said he only relied rely on the labeling that was on the seal that was made there, but that's what he relied on. So like one could have defenses pushing him onto the argument that somebody can write a label why it's not the blood of the person whose name is actually on the document. So you should confirm before you take a responsibility of which responsibility to take this blood and transport them to Ghana. So these were some of the arguments from the defense camp, and they also question in regards to the whole issue of the extraction of the blood, whether he was actually being present. But what we understand from him that he was only present when they were taking the alleged victims' blood sample and that of the baby Mohammed's sample. But all the three parties that were involved, he was not actually present to collect this blood sample. And also the transportation and the storage was not actually under his custody. He was just calling, and they went to the child ward in Banjul here, and they tell him this is the blood sample. He just pick it and put it in a cooler and then start transporting them to Ghana. So these were some of the arguments that the Defense Council was trying to push him to see that he's not a credible witness, just to make sure that this person doesn't know what actually he was doing. That was the trend that the defense was actually going. So whether he succeeded in that or not, that will be at the tail end of the case when we actually have all the facts before us. Then we will know that definitely these are issues that, before the court. Then they proceeded, and we have the expert who actually conducted this whole entire DNA process. And this person was here to give us at least how he get involved in the whole case, and he gave us that this was a letter that was sent to their institution. He's a police officer through their Inspector General of Police, that Gambia needed an assistant for them to actually help them in terms of determine a case that is before the state and Boubacar Keita, and they want a DNA exam test to be conducted in this area. And this is how, as a lab technician or expert in this area, he was consulted to do that. And Francis traveled from the Gambia, then go to Ghana, hand over the blood sample to him. He also do his analysis and come with a results in regards to this issue, and that's how the whole issue came. And he was like, if we proceeded, he will have disclosed to us, what was the content of the document, but this didn't happen because actually there was an agreement between the Defense Council and the judge in regards to the foundation that has to be followed before you lay what we call an evidence before the court. And he relied on the CPC, that's the Criminal Procedure Code section 75, capital C, and even he relied on A, that any document that the defense the prosecution intend to table or to use as an evidence in the court, the defense must be served. And he have made reference to so many jurisdictions, even not only Gambia, UK has been made an reference to, and also even Ghana has been made an reference to that these are not acceptable. And he also made a very important legal argument that prosecution by ambush is no more accepted anywhere. You cannot just come and ambush somebody in a court of law. Normally you brief him. That's why counsels are writing each other briefing, so that you prepare yourself in terms of your defense. What he's arguing that today what the judge is trying to do is a prosecution by ambush, because he cannot have the opportunity to actually cross-examine this expert, because he's not prepared. He was not served to know what was the content of the document, so that he will prepare his questions and answers. And actually, before he even start properly laying his argument, the judge said that if he had him, he will overrule him. And we had Ella saying that this has to be recorded in terms of a reference, in terms if he have to challenge this in a court of appeal or any upper higher court than the high court of this country, so that he can have it in the record. And MS Jallo was like, the judge was actually, it doesn't worth it for me to do that. But I was arguing based on law that if I listen to, I will use the same provision that you rely on to make this accusation to overrule you. But Ella said, you are preempting because you don't know actually what I want to say. But I'm quoting the constitution of this country that supersedes any laws in this country. So this has been the argument, and Ellis is ready to proceed when he comes tomorrow with his objection in terms of the foundation was not actually laid, the proper foundation where you can admit an evidence before the court. So he is arguing on the unadmissible of the evidence that the prosecutions want to tender as part of their evidence. And he also argued that there were no notification given to them regarding they have additional witness that will testify in this case. So that means that there was no list provided to them to indicate that they want another additional 2 witnesses. So these are arguments that Ellis is making, and he's relying on law. So we see what will be the outcome of the judge in terms of ruling his arguments that he is ready to do from here against tomorrow. So far this is, and we missed the opportunity to know what is the content of the document, and hopefully tomorrow will be done, because the man has to go back to Ghana on Friday. So hopefully we might get